Good evening and welcome to Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. Starting with an important update from the Kolkata High Court, which today transferred the investigation pertaining to the assault on Enforcement Directorate officers in Sandeshkhali, West Bengal to the CBI. These officers had gone to Sandeshkhali to raid the residence of ration scam accused Shahjahan Sheikh. A division bench of Chief Justice T.S. Sivangnanam and Justice Hirannamay Bhattacharya set aside an earlier order constituting an SIT with members of the state police and directed the state to forthwith transfer all papers concerning the matter to the CBI as well as the custody of the prime accused, that is Shahjahan Sheikh. The court noted that the state police had played a hide-and-seek methodology in all probabilities to shield the accused, who undoubtedly was a highly politically influential person who had shown that he would be in a position to influence the investigation if allowed to continue with the state police. Also, let me tell you, hours after this order was passed today, the West Bengal government moved Supreme Court assailing the same. The matter was mentioned before Justice Sanjeev Khanna's bench. In response to this, the judge directed the papers to be placed before Chief Justice D.Y. Chandrachud for further instructions. In the next important update, the Nagpur bench of the Bombay High Court has today set aside conviction of former Delhi University professor G.N. Sai Baba and 5 others in an alleged Maoist links case under the UAPA. Wheelchair-bound G.N. Sai Baba and his co-accused have been under custody since their arrest in 2014 on charges of having links with Maoist organizations and waging war against India. During the trial at the Sessions Court in Gadchiroli, Maharashtra, the prosecution had contended that the accused were working for the banned CPI Maoist group. It relied on evidence including seized pamphlets and electronic material deemed as anti-national. It was further alleged that Sai Baba handed over a 16 GB memory card intended for Naxalites sheltering in the Abuzmad forest area. The subsequent trial led to their conviction in March 2017. Then in 2022, another bench of the Bombay High Court had set aside the conviction based on procedural grounds. However, in a special Saturday sitting, which attracted controversy back in 2022, the Supreme Court had stayed the High Court order the very next day after it was urgently mentioned by the Maharashtra government. Later, the Supreme Court overturned this decision in a plea filed by the Maharashtra government challenging the acquittal and directed the Bombay High Court to re-evaluate the case afresh. Well, today, a division bench of Justice Vinay Joshi and Justice Valmiki S.A. Menis pronounced the judgment, setting aside their conviction. Also, after few hours of this, the state filed an application before the High Court seeking to stay the implementation of the acquittal of G.N. Sai Baba and 5 others in this case. In the application, the state stated that it has approached the Supreme Court against the acquittal order passed in the morning, but the High Court rejected the application. In an interesting update, Kolkata High Court Judge Justice Abhijit Gangopadhyay has resigned and has decided to join politics. He announced his decision to join the Bharatiya Janata Party today. In an interview with local news outlet, Justice Gangopadhyay had on Sunday revealed his plans to step down. His decision to resign comes with 5 months left until his scheduled retirement in August this year. I must tell you that Justice Gangopadhyay has been mired in controversy throughout his tenure, culminating in his disagreement with a division bench led by a senior judge in January this year. Not only did he defy a stay order issued by the division bench regarding his order directing a CBI probe into purported irregularities in medical admissions in West Bengal, but he also made damning allegations against Justice Somen Sen. Also last year, he was criticized by the Supreme Court for giving an interview to a local Bengali news channel regarding the infamous cash for jobs scam in the state while presiding over a batch of matters relating to the scam in question. In this interview, Justice Gangopadhyay allegedly made imputations against TMC National General Secretary Abhishek Banerjee. In a significant development, the Supreme Court has decided to refer the issue of automatic transfer of insurance policy when a vehicle ownership changes under the Motor Vehicle Act of 1988 to a larger bench. The bench of Justices P.S. Narasimha and Arvind Kumar referred the issue to a larger bench after witnessing an inconsistency amongst its earlier rulings in two cases. These cases are Complete Insulations Private Limited versus New India Assurance Company Limited and Surendra Kumar Bhilave versus the New India Insurance Company Limited. While the judgment in Complete Insulations held that deemed transfer of insurance policy on sale of vehicle will take place only with respect to third-party risks, the judgment in Surendra Kumar held that deemed transfer will be applicable to the whole policy. To tell you about the facts of this case in brief, the appellant here had bought a car from another person and asked to change its registration. The previous owner had insured the car in 2009. Then two things happened on 25th March 2010. Firstly, the car's registration was changed to the new owner's name, and secondly, the new owner had an accident while driving the car. After the accident, the new owner, that is the appellant, asked the insurance company for compensation, but they refused it. So he filed a consumer complaint with the District Consumer Disputes Redressal Commission, and the forum allowed his complaint. The insurance company then appealed to the State Commission, arguing that according to Section 157 Clause 2 of the Motor Vehicles Act, the new owner should have informed them about the change in registration within 14 days. Since the new owner did not do that, the State Commission agreed that the insurance company was right to reject the claim. Further, the NCDRC dismissed the revision petition filed against the State Commission. And now the matter is before the Supreme Court. In another important update, the Supreme Court has today allowed appeals filed by Karnataka Deputy Chief Minister D.K. Shivakumar and his aide challenging criminal proceedings in a 2008 money laundering case. The background here is that allegations of money laundering were levelled against Shivakumar and four others following income tax raids in the year 2017, where unaccounted cash worth over rupees 7 crore was reportedly seized. Enforcement Directorate had issued summons to them in connection with the raids under Prevention of Money Laundering Act. Further, in 2019, the Karnataka High Court had dismissed a petition by Shivakumar and others upholding the central agency's summons. In the same year, when they approached the Supreme Court, it issued notice and had also protected them from coercive action. A bench of Justices Suryakant and K.V. Vishwanathan today allowed the SLPs filed by them against the High Court's verdict. The primary reason cited by the High Court was that Section 120B of IPC constitutes a stand-alone offence adequate to invoke the PMLA. But this rationale has been held as unsustainable by the top court in view of its recent judgment in Pavana Debur case. In this case, it was held that Section 120B of IPC becomes a scheduled offence only when the conspiracy is directed towards committing an offence that is otherwise scheduled. Referencing this judgment, the Supreme Court today allowed the appeals of D.K. Shivakumar and his aides. However, it noted that a review petition has been filed by the ED against the Pavana Debur judgment. Accordingly, the bench clarified that if the review petition is accepted, the view taken by the High Court in the impugned judgment will stand affirmed, allowing ED to seek a review or recall of this latest order if necessary. The Supreme Court has held that a case under Karnataka Prevention of Cow Slaughter and Cattle Preservation Act is not sustainable when the sample of meat was seized by an officer who was not authorized to do so. A bench comprising Justices Abhay S. Oak and Ujjal Bhuya upheld a judgment of the Karnataka High Court which quashed an FIR under the Karnataka Prevention of Cow Slaughter and Cattle Preservation Act on the ground that the sample was seized by an unauthorized officer. The court was hearing an appeal filed by the informant challenging the High Court's decision to quash the case. After perusing Section 10 of the Act, the court concluded that the power of an authorized person is confined to only enter and inspect. However, in the instant case, the assistant director, who was an authorized person, not only collected the sample of meat but also sent it for analysis. The The Supreme Court bench of Justices Abhay S. Oak and Ujjwal Bhuya categorically held that the said person had no legal authority to collect the sample and that this was completely illegal. The Supreme Court has directed State of Uttar Pradesh to inform about the details uploaded on e-module framed by the National Informatics Center, that is NIC. Pertinently, in this e-module, each state was required to upload the necessary information including status of the convict, the number of years he has put in and other such details. Moreover, as per the Supreme Court's directions, all states were required to adopt this e-module. The division bench of Justices J.B. Pardiwala and Manoj Mishra passed this direction while hearing an appeal seeking to quash the remission policy brought in by State of Uttar Pradesh in the year 2021. As per this policy, the remission benefit could be extended only to convicts above the age of 60 years. It was pleaded that the same was arbitrary and illegal. During the hearing, an advocate appearing for the National Legal Services Authority pointed out the directions passed regarding e-module. The council further pointed out that all the states have started complying with the directions. However, the last status is unknown. In view of this, the Apex Court directed the state to file an affidavit furnishing the details uploaded on the e-module. And lastly, the Supreme Court has expressed surprise at Madhya Pradesh State Tourism Development Corporation challenging an order of National Green Tribunal which was aimed at saving lakes in the state. The bench of Justices Abhay S. Oak and Ujjwal Bhuya were hearing an appeal against an order passed by NGT Bhopal in an application raising grievance of serious damage and deterioration being caused to Bhopal Lake and other water bodies due to operation of motorized boats and cruise boats. The NGT had restrained the authorities from running cruise boats or any other boat operated with motors in the lake. Against this order, Madhya Pradesh State Tourism Development Corporation approached the top court. Dismissing the appeal, the court remarked that the appellant's approach should be to ensure that more and more lakes exist. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.